right, great. Well, good afternoon, everyone. Thank you for joining us. As we all know, the government contracting community plays an important but niche role within the greater DC community and has very specific needs. We welcome the opportunity to introduce you to a team of professional advisors who concentrate on government contracting and are dedicated to making sure that this industry and this area continue to thrive. We're always happy to be resources and help you however we can. And with that, I'd like to introduce you to our esteemed panel. I'll start with our hosts at PilieroMazza. We have Alba, partner in government contracts, and Kathryn Hickey, partner and practice group chair of business and transactions. PilieroMazza is the go-to law firm for contractors navigating the complexities of doing business within the federal government. Their clients benefit from the firm's personalized services and collaborative approach to delivering holistic and effective solutions. Next, I'd like to introduce the team at Aronson. We have Clint Woofter, Director, Government Contract Services, and Bill Foote, Partner, Financial Advisory Services.
Hi there.
Aronson is a CPA firm that provides a comprehensive platform of assurance, tax, and consulting services focused on the government contracting industry. From startup to exit, Aronson helps clients maximize opportunity, minimize risk, and unlock their full potential. And lastly, I'd like to introduce my team at M&T Bank. I have Greg Smith, Business Banking, Regional Manager of Washington, D.C. and Suburban, Maryland. And John Halley, Business Banking Team Leader of Prince George's County and the head of M&T Bank's Government Contracting Vertical. And I am Pat Braunscheitel, Business Banking Relationship Manager in Washington, D.C. M&T Bank is a small business bank that focuses on finding creative ways to serve small to mid-sized businesses, especially in the government contracting space. This local team is dedicated to growing relationships within the government contracting ecosystem in the DMV, helping to facilitate introductions amongst companies serving various agencies within the DoD and IC, along with providing companies the capital needed to grow and scale throughout their life cycle. Now that we've introduced everyone, I'd like to get the conversation started and open it up to the panel with our first question. And what brings us here today is, why does it make sense to have professionals from accounting, banking, and legal on your transaction team?
Who wants to start?
I'll kick that off myself. So I typically come to a transaction on the legal side, and we often get questions from clients when we, we'll be talking through in advance of a deal. Maybe they're working through an LOI, and they have a question about, say the calculation of net working capital, or, how are we going to make sure that this earnout is achievable, or something along those lines. And I'll give them my thoughts, and then I will also advise them to pull in their accounting team to weigh in on those items that really pertain to accounting issues. Or, another situation that can come up is we'll be reviewing a purchase agreement, and I'll say, we recommend having the agreement reviewed by tax counsel to address the tax provisions. And they'll say, well, but what about my CPAs? They handle my taxes. Can't they just do that support here? And the answer is there's a lot of overlap between what an accounting advisor will weigh in on, and a legal advisor, and also your banking relationship, because we do deals all the time and we've all seen them, but we come at things from a different perspective and with a different depth of expertise on certain aspects of each issue, all of which are important for a party to a transaction. So the advice that a CPA might give on tax provisions in a purchase agreement might be very helpful, but slightly different than what tax counsel might give. And that's just one example, but I do think it's important to leverage the depth of expertise that those different advisors can bring in order to make sure that you're getting, the full spectrum of advisory services and looking at all the issues from every angle, which is what they can do.
Yeah, I would just add it is it's a even relatively simple transactions have their complexities. So there's multiple disciplines that need to be involved in the process, and so coordinating among legal, banking, accounting, and collaborating is that's important, and the sooner the better, I would say.
Yeah, and it's also important. I've had transactions before where we had everything buttoned up during the transaction process, but post closing, the individuals didn't fully understand the implications of the transaction on some of their taxes and things like that. And so we had accountants there and we had tax lawyers to structure the deal and to do the diligence and all of that work. But I would say that's also where your accounting team, and it might be the same people that you've worked on in the transaction, which is always good, but your accounting team really needs to help you too after the fact. And that I think is less so with a tax lawyer, unless maybe there's some sort of dispute or really complicated scenario, or there's like trust issues and things like that. But just from the basic perspective of understanding, okay, the transaction occurred, the new ownership structure is X. You know, what does that mean for me? If you're, especially if you're selling and you're staying on and keeping a piece of it, that's where I've seen most of the issues come up, where in smaller transactions in particular, where there might not be a third party buyer that's completely unrelated to anyone. It's people who everyone knows, and we're bringing other guys to the table with some equity. And then the prior owner might continue to use the earnout payments or things like that and not treat it appropriately. It might just start taking all the funds out of the company, and the other guys won't be paying any taxes, even though it's an LLC, and things like that. And that can get you in trouble down the road with the IRS. So, you know, just realizing at the different stages as well, who's important and keeping everyone up to speed.
Hey, Pat, this is Greg, and sorry, my webcam's not working, so everyone will just have to imagine my headshot there talking to them. But I think from a banking perspective, you know, reiterating what everyone else has said, you know, the partnerships and the collaboration between the different partners is essential, and having a strong relationship with your bank is also very important, because your banker can help brainstorm different ways to handle the transaction, you know, from a structure standpoint. But, you know, that banker is going to have to, you know, work with their underwriting partners and management. So, you know, having that existing strong relationship with your bank is critical, you know, when it comes to the transaction standpoint, because you have that track record already. But, you know, the banker can work with the other, you know, partners and come up with, whether it's, you know, traditional financing or SBA financing, or if it includes earnouts or seller notes. You know, we have experience, and if our group doesn't have it, you know, our middle market and corporate group does. So, you know, we have a lot of different partners that can help us.
You know, that also reminds me of one other thing too about like privilege. So if there's some issue that comes up during diligence and there's a problem, let's say there's a tax problem, or there's in the GovCon side, there's a problem with how you've been running the business. Another thing I've seen is like there's a lot of different consultants out there, and you want to be careful what you're talking about with whom, because if you're not talking to your lawyer, or a lot of times what we'll do, including with Aronson and stuff, sometimes the law firm will engage the accounting folks and other people through us, and if something like that comes up, so then if we're getting guidance from them to provide legal advice to you, the entire chain is covered by attorney-client privilege, as opposed to if there's a advisor, non-lawyer consultant or something, and you're talking to them about all kinds of different things or some issue that comes up, they could be subpoenaed. So just be aware of that as well before you're talking about sensitive issues. I think that's it from I don't know if there's any other issues.
Sorry about that, guys. I was on mute. But thank you for adding that at the end, Si. We have our team of advisors here, and the next biggest thing in this process is setting expectations with our clients. And there's many things that can come up doing due diligence, and from pre-closing to post-closing. There's many different things that can occur for good or for bad, but I think it'd be very helpful for our audience if you could walk us through an acquisition timeline and what that would look like, and some of the things to expect during that process.
I think I'll just briefly mention a few things in terms of timeline. Every transaction is different. Every organization is different, right? So sometimes acquisitions take place over an expedited time frame, matter of months, but other times deals are years in the making. So it really has a lot to do with management team dynamics for the target company, the company being sold, and the ownership group as well that has a pretty significant impact on the timeline.
Bill, I'd just add to that, and I'll echo exactly what you just said. Every deal is different. I would say, in terms of best practices, if an acquisition is top of mind organizationally, and it's something that you're exploring, I would highly recommend looping in your banking partner, your legal partner, your tax partner, CPA, as early in the process as you can, really, to be a resource. Even if you don't have a target currently identified, you can start running those rough numbers and just understand what your buying power is if you're the acquirer.
I completely agree. I think it's always in a company's best interest to make all of your key advisors aware if you're anticipating a potential transaction in the foreseeable future. As soon as that becomes something that you think is going to happen, say within the next 2 to 5 years, which might sound like an incredibly long lead time, but there's a lot that your advisors can do if given sufficient advance notice to help put you into the best position when you do go to market, if you're anticipating a sale, or when you do actually come down to presenting an LOI for a potential strategic acquisition. There are things that you can do to try to position yourself financially, to get your legal house in order, to minimize the diligence process and the cost and expense associated with that, to make sure that you've done what you need to with your banking relationship to have sufficient, capital access to fund a potential purchase, or to provide operating capital for, a larger business going forward. And those things are going to be easier to implement when you don't have a party across the table from you, and when you don't have the pressure of a closing deadline. So earlier is always better. And, just make sure that you give everybody a lot of breathing room. It's going to work out in most cases to create a more efficient transaction process once you really are at the LOI stage.
And we might get into some of this later too, but to that point, we have a lot of transactions where someone will email us. It could be a client we've had for years and years and years. We'll email and say, hey, we just did this. We got this LOI, we signed it, we're ready to go. Now I need some help. And especially if you're the seller in that case, and you have if you're a small business, or your legacy small business work. And I know we talked about this before in other presentations, but there's something called the present effect rule, where SBA will treat, in some circumstances, depending on the language in the LOI, they'll treat the signing of the LOI as tantamount to signing of the entire deal and closing the deal. And so if your LOI is too specific, if you call it that, under the rule, which frankly sellers want, but it can trigger this problem for SBA, where if it looks like the deal is already done, an agreement in principle is what they call it, then you're going to be stuck in a situation where you might not be able to bid new work and potentially new task orders under IDIQ contracts as a small business anymore. or at least if you are doing it, you are potentially at risk if there's a size protest or something like that. Same thing if you're looking to acquire a company, and let's say they're looking to bid on CSP4, which just went in, or Polaris, which is going to go in pretty soon, and they're bidding under certain categories, and that bid is going in after you've signed the LOI, and you're thinking, well, I'll get it, and I think this one big task order they're bidding on, they'll keep us or something like that. Well, if they've bid it in that period post LOI, and if the LOI has language in it that trips that rule, they might not have been eligible for that. So if you buy them thinking the government won't terminate that, and then there's some whistleblower, some other thing happens, or a size protest or something after the fact, they might lose that or worse. So just be aware that it is important to get involved early in the process before you might think you'd want people involved. And I know a lot of times people think, well, I don't want to call people, everyone's going to start charging me. But that's kind of, at the LOI stage, if there's this issue, we might want to talk about it, and it might be a couple hours here and there. But earlier on, it's not something that's going to cost a ton of money, and it will save you a ton of headache down the road.
Yeah, and then I guess just on another thought, we've been focusing on the pre and the actual closing, but then the post-closing, at least from my perspective, that tail it can last a year, 2 years, 3 years, because there are a couple things that you got to consider. After you've closed and you're starting to merge the two companies together, do you go through contract novations? That can take months, a year with the contracting officer. Do you change the name? Do you integrate business systems? Then you have the tail of, it was just mentioned by Cy a little bit, is you're a small business prior, and now you're no longer a small business, and then how that's going to impact your proposals and awards going forward. So there's a lot of things to consider after closing that'll have to get wrapped up from the government. And unfortunately, the government doesn't move at 55 miles an hour. They move at 25 miles an hour.
Exactly.
Mm-hmm.
Yeah, the only other thing I'd mention too, and this may be like getting very basic in terms of the timeline pre-closing, engaging your banking partner, giving them a proper amount of time to really break down and understand what the transaction is going to look like once you've come to a draft agreement of sorts. There may be additional documentation. I know we'll probably get into that here shortly. That may require some time from your back office finance team to really prepare so that the bank can get comfortable approving a transaction. And then obviously if some of the due diligence aspects, valuation, et cetera, haven't occurred yet, you want to bake in some time for the collection of documentation, for the bank to run their analysis, and then obviously for the additional due diligence to occur. So I'd say at least 30, preferably 60 days in most cases to get to that green light to move forward on the banking side.
Yeah, and thank you for that, John. I think everyone on the call would, agree that the earlier having your advisors looped in the better. We were briefly talking about going to market, and I'll address this question to Bill, John, and Kathryn. But if we could just touch on it and what situations it makes sense to have an earnout as part of the transaction.
So it might make sense for me to start, because my answer is going to be a little bit more big picture, and then my guess is going to be that the bankers and accountants might have more specifics to offer. So generally, broad strokes, an earnout is usually going to be most helpful to bridge a gap in perceived company value, where the buyer, has looked at the numbers, looked at your backlog, and put a potential value on the company, and the seller says, no way, I'm worth more. Usually an earnout can help bridge that gap, because the buyer is only going to come out of pocket up front for that amount that they've clearly determined it is current value. And then to the extent certain performance milestones are hit post-closing, they're willing to concede that if those milestones are hit, that's an indication of greater value. We'll pay you if and when those milestones are achieved. For government contractors in particular, earnouts are often key when there are material contracts involved in the transaction that might be coming up in the relatively near future for recompete, or if there is, an asset transfer component and certain contracts need to be novated. In those instances where whether or not a valuable contract is going to remain with the company post-closing, the companies may agree that a certain portion of value attributable to those vehicles is going to be contingent consideration that will only be paid once the parties have, won the recompete or received the novation, at which point everybody knows that that value was realized. And so it helps to protect against certain uncertainties that pertain really to value as of the date of closing. So that's the high level answer from the legal perspective. And then I'll let some of my colleagues who crunch the numbers weigh in as well.
I've been accused of being a number cruncher before, so I'll just jump in briefly. I think Kathryn, you hit the you hit it. I'll just talk for a second about mechanics, since that's another consideration, and try to tie it back to what you were discussing. So we talk about earnout, we're talking about contingent consideration, right? So consideration that's going to be paid after closing, based, dependent on some future event. And so from a mechanics standpoint, the calculation can be based on revenue. It can be based on something lower on the income statement, right? Gross profit, EBITDA. Very frequently, it's based on EBITDA, or it could be based on a combination of those metrics. And from a buyer versus seller standpoint, right? You might be more inclined as the seller to have your earnout measured on revenue, as opposed to EBITDA, since in a lot of situations post-closing, you're not going to have control over the operating costs and infrastructure anymore. And then going back to what Kathryn mentioned about specific contracts, whether it's a recompete or there's some big contract award that's looming in the next 6 months after closing. A lot of times in government services deals, or at least more frequently than under other industries we work in, we will see a binary, non-financial earnout based on just kind of a yes, no. Was the contract awarded or was it not? And then obviously there's numbers behind it, but the key trigger is just a yes, no.
Bill and Kathryn, really appreciate you really giving that the high level piece there. From a more granular aspect, I'll give you the qualitative versus the quantitative factors that we take into consideration over on the banking side, right? So oftentimes the deal's structured, right? It's been hashed out in terms of what it's going to look like when the bank gets brought in. So a couple of things for us to really understand and have communicated to us is, hey, why the earnout? Like, just help us understand that, explain it. Is it to ensure that a contract's awarded, or that you're ensuring company culture and integration post-closing, right? There's rationale there. What it does do, I will say this, is it potentially limits how the bank can structure a deal. So oftentimes, because of the leverage that's being folded into the balance sheet with an acquisition, in a service-based industry, our collateral coverage is going to be limited. So there are mechanisms, primarily the SBA, that the bank can use to get comfortable with the transaction. The one thing that I will say with that is the SBA has very stringent guidelines on earnout and restricting some of that. So it may restrict the way that you do your deal. You may have to go conventional versus SBA. And then another thing to consider there is depending on the amount of liquidity that you have to inject into a deal, that may guide the route that you have to go as well. So the SBA provide you with an opportunity to only inject 10% versus on a conventional basis, banks are looking at 20% oftentimes.
Thank you, John. And you briefly touched on it here, and I'm going to go back to you on this next question. You're talking a bit about leverage and liquidity, but if you wouldn't mind just talking about how working capital, can impact a purchase consideration.
Sure, I can jumpstart us there. So mentioned it just a moment ago. So oftentimes large dollar amounts with these acquisitions, they could potentially eat up a good chunk of liquidity on a company's balance sheet. In doing so, taking the bank view, we want to take into consideration, hey, what does it take to run your business post-acquisition, especially folding in X number of employees? We want to ensure that there's sufficient working capital there to make payroll, because if you can't make payroll, it's a moot point, right? So that is one thing that the bank will take into consideration is what's the appropriate line of credit size to serve as that safety net post-acquisition so that you can continue operations if a large amount of liquidity is utilized towards accomplishing the closing of an acquisition.
And John, just to add to that, in terms of the size of the line of credit, 2 to 3 months payroll is usually a good marker.
And I'll jump in for a second. In terms of how you measure working capital, right? We've talked about, funding payroll. It could be a broader view of operating expenses for X number of months. A lot of organizations think about working capital in relationship to revenue. So maybe as a percentage of trailing revenue. But mechanically, there's just a couple points I would make from a deal perspective. One, typically working capital is going to be measured on a cash-free and debt-free basis. And then going back to our timeline discussion at the outset, there's in a lot of agreements, purchase agreements, and I'll save that for Kathryn to talk about, the purchase agreement itself. But very frequently in government contractor acquisitions, there's some working capital peg that's established, and then there's a measurement at closing against the actual amount of working capital that's delivered. And there may be an adjustment to the purchase consideration at closing. And so going back to timeline, when does that peg get established and by who? Sometimes that gets established and documented in the letter of intent. Other times it's left open to be determined through diligence. I'm not sure what how that breaks down in terms of what's the most common, but just a couple points from an accounting and timeline standpoint.
Yeah, thank you for that, Bill, John, and Greg. And factoring in today's environment, between the COVID-19 pandemic and payroll protection program between rounds 1 and 2, there's been some implications that, as it's affected deals. Kathryn, I'd like to start with you on how you've seen, between COVID-19 and the payroll protection program, how you've seen that affect deals that you've seen over the past 18 months.
Sure, it's interesting because they've become a pretty ubiquitous feature of transactions that are happening now, and I think that's going to continue for quite some time because the lingering effects of the COVID-19 pandemic in general, as well as the Paycheck Protection Loan Program, are going to stick around. So some ways that it's changed how M&A transactions are structured or handled with respect to PPP loans. The further out we get from the forgiveness deadlines for those loans, the less of an issue this becomes. But to the extent a company that's engaged in an acquisition has a paycheck protection loan that has not yet been fully forgiven, that needs to be addressed in the acquisition and in the sequencing. Under the SBA guidance, any outstanding loan is going to require consent of the lender and the SBA for a change in control transaction or a transfer of substantially all the assets, unless the borrower escrows the full amount of the loan with the PPP lender as essentially security protection for that loan in the event it's not forgiven. So this is becoming, it was much more common in the first half of 2021 when nobody had forgiveness yet. Now, as more loans are forgiven, it's becoming less of a feature, but not all loans are forgiven, so that is something to keep in mind. From a diligence perspective, borrowers are still very much focused on if they're acquiring a company that received a Paycheck Protection loan, were they eligible? Did they properly certify whatever they had to certify to the SBA to get that loan? When they submitted for forgiveness, was their application for forgiveness proper? Did they use the proceeds in accordance with the permissible and forgivable uses under the law? And there's concern about audit risk associated with all of that stuff, even for forgiven loans. So those are definitely going to be addressed in the representations and warranties. To the extent the buyer in diligence looks at the documentation and identifies a risk, it may be the subject of potential special indemnity or an additional escrow, even if the funds have been forgiven. Cy and I are actually dealing with this right now because there's a particular concern with respect to government contractors, and depending on how your contracts are structured from a pricing perspective, and how the receipt of Paycheck Protection loan forgiveness can impact cost submissions to the government customers, and what do we need to be concerned about there. So maybe I'll stop talking because I think, Cy, would you like to expound upon that point? I think it's really relevant for some of the government contractors who might be listening in to the webinar today.
Sure, yeah. So what Kathryn's talking about is, if you get PPP loan forgiveness, DCAA has sort of considered it to be a credit under the FAR 31 credits clause. And so what that means is, in particular, if you have cost reimbursable contracting, like cost plus fixed fee, cost plus award fee, that kind of stuff, and you're tracking your costs, then if you get this forgiveness amount that sort of zeroes out those costs that you've already billed the government, then you are probably going to have to give that money back to the government to cover the costs that they've already paid you for. I don't think, and I can let some of the accounting folks weigh in too, but I don't think it applies to firm fixed price or to T&M work, except in certain instances. I think there's an argument that if you had a modification to a contract that wasn't competed and it was over the TINA threshold, which I think is still 2 million, then at that point you should have provided cost and pricing data, and there should have been a price analysis performed. So if somebody wanted to get really aggressive with it, I think for those modifications, they could make an argument that the credits clause applies, even if the underlying contract was firm fixed price. So things like that are issues that we've been looking into and looking at for potential buyers, so that they're aware of the situation, and that sometimes that's created higher escrow and things like that, because we still haven't heard what the final guidance is going to be on these issues and how it's going to be treated. But I would imagine as some of the indirect rate proposals and things like that start getting looked at later this year, early next, then we're going to have a situation where it'll be a lot clearer, and we'll have some data points at least of how they're going to deal with that.
Yes, hi, this is Clint. Yeah, all that would get flushed out, as you mentioned, through their annual submission, and would get flushed out against the cost type work, unless there's an exception somewhere, but it's usually the cost type work.
On the banking side of the house, I'm super happy and thrilled that Kathryn and Cy were the ones to go first here, because they really laid out the implications of forgiveness and then the escrowing of funds depending on how the transaction occurs. So I appreciate you both really diving into that. One thing that I would just leave the group with here on this topic is have a discussion with your banker, with your bank, in terms of how they're viewing PPP funds, in terms of calculating their ability to pay, the debt service coverage ratio that they're looking at when they're doing an analysis. Banks may be pulling those PPP funds out from the other income aspect, just to really get a sense as to how the organization did in 2020, 2021.
I think the other part of this question addressed just COVID-19 in general, unless others had stuff that they wanted to add about the PPP loan program. The broader issues that we're still experiencing, frankly, arising out of the COVID-19 pandemic are also showing up in transactions. There is, I think, a kind of a new area of diligence that a lot of buyers are focusing on to identify what a target company has done to comply with any mandated changes in protocols or procedures or other regulations or laws that arose out of the pandemic. So whether that's, implementing, any sort of health and safety measures with respect to your employees, and how that's impacted their operation of the business going forward. So that's going to be a large part of diligence, compliance, not only with the mandatory legal and regulatory requirements associated with the pandemic, but in addition, how have you changed your practices? How have you changed your workforce? And what does that mean for an acquirer coming in? How does your business operate now in the pandemic world? And what is it going to look like coming out of it? Have you experienced any negative effects with your workforce, with your supply chain, with your vendor relationships, with your customer relationships as a result of the large economic impact of this worldwide event? Pretty much every target company has been impacted in some way, and that's impacting value. It's impacting how companies approach diligence, and it's definitely changing, the M&A landscape in a way that I think, frankly, is probably never going to fully go back to normal. So it's different with every deal, and it's different with every industry, but something to keep top of mind as you go into figuring out how to get your arms around a company as it may have been impacted by the COVID-19 pandemic.
I think from again, from a broader perspective, from a financial perspective, right? Like we've said, PPP to a degree is in the rear view now. But when we're thinking about financial due diligence, right, we're analyzing in the rear view, right? Typically, we're identifying some historical time period to look at, whether that's just the last 12 months or whether it's the last 2 fiscal years plus the trailing 12 months. So these impacts are still going to be visible and have to be dealt with. And from an EBITDA standpoint, there's all sorts of implications. It may, for some companies, drive certain costs up. In other situations, it may drive costs down. During the pandemic, a lot of companies are, not traveling as much, obviously. Might be an impact on training costs, you name it. But there's definitely a lingering impact on the financials. And, we have to understand that both from the seller's perspective and the buyer's perspective.
John and Greg, was there anything you wanted to add before we move on to the next section?
I think Bill and Kathryn did a good job there.
Awesome. Well, great. Before we focus on our next topic, focusing on the sell side, I do see a number of questions coming in. I do want to note that we are keeping track of these questions, and in the follow-up email, we will make sure that all of these are addressed. So I'm taking note of these, and we'll make sure all the applicable parties from this panel get follow up and give you answers along with their contact information. So next, the next series of questions, I'd like to focus on the sell side, and first start off with small business set-asides and the impact it has on the pool of potential buyers, as well as some of the legal and contract considerations. If it's okay, Sai and Kathryn, I'd like to start with you on that question.
Sure, yeah, I can jump into some of this stuff. So, you know, we obviously do a lot of work with small business sellers and buyers. And the issue on the sell side, right, is really understanding what your value is and knowing too what you're getting into. So if you have a lot of 8A contracts, first of all, if you're using even a multiple or something like that, it's going to be far lower, right? I had one client recently who has a informal mentor advisor who noted that in the commercial marketplace, the type of work that this person did was going for like 10x, which is very high in the GovCon space. And because this work was all 8A work, I kind of had to tell him, like, you know, I'm not a valuation expert, but I can tell you, you're not getting 10x on a bunch of 8A work. You're going to get like 2 maybe. And it's such a different world. And so realizing that, because there's only a few buyers who, especially if you're a larger small business, there's only a few buyers that can come in if you're 8A and buy you, because there's all kinds of regulations that essentially the contracts have to transfer. I know there's very narrow exceptions, but they have to transfer to another 8A company. And then the next thing people say, for instance, if they're 8A, is, oh yeah, you know, do you know any tribes or ANCs that want to buy me? I was like, maybe. But they also know that they're one of the only games in town, and they're going to drive down the value. I personally think it's probably a much better proposition for an 8A company to use the program sort of as intended and grow themselves and then move out of it until they at least have vanilla small business work, if not full on open, and then go to market. But because of that, and you're talking about potential recertification that has to happen, if you're bought, you have to then recertify within 30 days of the transaction. If you're no longer small, there's all kinds of implications. So for IDIQ contracts that were awarded after May 25th, 2018, you're in a situation where if you recertify as large, even if you're allowed to keep the contract under its terms, you can no longer bid task orders under that period. So it essentially eviscerates the future value of that IDIQ vehicle if it was after May 25th, 2018. The other thing can be, let's say you have bids pending and you're acquired. Well, the new rule that went into effect in November of last year, less than a year ago, says that if the transaction occurs within 180 days after you submitted the proposal and you close the deal, then at that point you have to notify the contracting officer that you're no longer small, and then you're no longer qualified to accept the award. If it's after 180 days, you can accept the award, but they can't take credit. The agency can't take small business credit for your work anymore. And note what I said earlier, if it's an IDIQ contract, not only can they not take credit, but you can't bid any task orders. So in theory, you're eligible to get the contract, but not use it. So what's the value in that? There is none. And if you've got a bunch of contracts that are 8A or woman-owned or service-able vet, those contracts are specifically tied to the individuals who hold them, not the business. So the person who owns the business is the one who qualifies for those. So if you have a lot of service-able vet work, you need to recertify as an eligible SDVOSB. You're going to need a service-able veteran company or a service-disabled veteran individual to buy you. Same with woman-owned, same for 8A, you're going to need an 8A company or someone who's qualified to be eligible for the 8A program. And so all of these things come into play. And remember too, even if you're just a vanilla small business, if all your work is, say, a $14 million size standard, and you currently have a 5-year average of 15 million, then, and that's all your line of business is in NAICS codes that are the $14 million size standard, it's essentially impossible or it is impossible for anyone to buy you, even if an individual comes in with a company that has like zero in revenue. They just created a shell company to buy you. If that individual comes in and acquires you, then they're already over the $14 million size standard because you are already over it. And so if you have vehicles like Oasis, for instance, that has a very draconian off-ramp provision, that you grew outside of your size standard organically. And so if you're at that like 5-year period where there's the next option coming up and you grow organically, you can side ramp into the full and open Oasis realm. But if you grow because you're acquired, you can't. And if you're acquired from a business and you're already large and you recertify as large, I think you have a problem there. You're probably just going to get off-ramped from that contract or that type of contract. So you need to be really aware of the entire situation and understand that depending on your facts and circumstances, your buyer pool might be infinitesimally small, which is going to mean that your value goes way down, especially if you're in that bucket where all your contracts are of a certain NAICS code that you're already over it. That really, really, really is going to hurt you unless you have some special IP or something of that nature. So I think those are some of the main concerns that we see all the time on the small business side. But did I forget anything, Kathy?
You really hit most of it, Sai. I mean, from a pure logistics perspective, the review of your individual contracts is always going to be really critical. It's good to know going in that certain broad statements are true, which is like if you have a preferred bidder status that's tied to WOSB or SDVOSB certification or 8A status, that is going to be really important to understand how much of your value is tied up in those contracts and what does that mean for a potential buyer who's not able to continue that certification. The reality is you're going to take a hit on those and you're going to have a more limited pool of potential buyers. Which doesn't mean that deals can't get done. We see them done all the time, but it's good to know strategically going in. It's also really important that you get advisors involved who understand how those vehicles, how those types of contracts play into valuations of companies and how those can impact the way that negotiations for a transaction play out. And this is particularly important if you're talking to, like an advisory firm, say you're talking to Aronson about helping to put together a valuation for a potential target company based on their backlog, or you're going to market, they're going to know what your vehicles are worth to a buyer and what types of discounts might be applied based on set-aside status. That's not the case for many other very excellent accounting firms who just don't do work in the small business government contracting space. And the same is true for your lenders. When you have a lender who needs to understand an acquisition proposal and the value of the company being acquired, talk to people like M&T who lend to government contractors all the time, who understand how to lend against these assets and who know what it means if a contract is set aside versus full and open. So those we've seen transactions that have really gone sideways because, again, very excellent lending institutions or other advisors are involved but just don't have familiarity with these types of assets and have a hard time wrapping their heads around how that impacts the deal. So I think it's good to have on your radar and make sure if you're interviewing potential advisors that they really do know the space and the industry.
Agree.
Yeah, well done there, Kathryn and Sai. You hit on the narrowing of the potential buyer pool there. Just want to give you a peek behind the curtain real quick in terms of what we're looking at when we're examining the backlog reports of the potential target. Right? Is you hit on is the set aside work going to continue? That's super important to us, because if it's not, then what's the impact, like post day one, post closing, to the continuity there again of the business? And then revenue concentrations. There's a point here. If we're seeing that all of the work being performed is at one agency or with one prime, or all awarded under a set aside, that's just risk. And if you think about the three parties here, we're all risk adverse groups, and we're trying to understand what the impact is going to be to the business if something negative happens. Not to say that there will be, right? But the what if plays a major role in how we're making our decision, at least on the banking side.
You know, there's something you touched on with the risk issue that I'd like to note too, because I've sat down with buyers before or sellers who are a bit more or less risk adverse and want to know, well, you know, is there a way around X rule or Y rule? And like say recertification. Kind of, there is some things that you could try that have never been tested before that I think are decent arguments to get around recertification and deal structuring. But in order to do that, you have to, if you don't have like just a ton of cash in a vault somewhere, you know, it might not work practically speaking, because the banks aren't usually willing to say, oh yeah, sure, how much you need? You need $10 million, and this whole thing might fall apart because you're doing this thing that's never been tried before. That's a practical consideration there. So just realize that no matter how creative you are willing to get, there's a lot of people here that you need to rely upon who you know, might not be willing to take the same amount of risk that you are. And so looking at it practically is just as important as, you know, trying to be super creative and get things done.
Not to belabor this point too much, but to the extent you have EightA contracts in particular, just from a deal timing and structuring perspective, that is typically going to necessitate, depending on who the buyer is and how the assets are being transferred or the company being acquired, you're in almost every case going to have to go to the SBA for some type of approval or waiver of the transfer of ownership or control of those contracts, and it's going to add lead time. Sometimes it's going to have to change how you structure the closing. So just want to put that on the radar for anybody who might be dealing with EightA contracts in an acquisition. We do it frequently, but it definitely adds a pretty big wrinkle to things. So it's good to just be aware and know that you're going to have to work through it.
No, and thank you guys.
And even if you have graduated from the EightA program, but still have legacy EightA work.
Thank you, Kathryn. Thank you, everyone. A lot of good nuggets to pull from that dialogue. And shifting to the accounting side, and Bill, if you could touch on this for us, is walking us through, you know, what a quality of earnings analysis is, and what circumstances it makes sense to do a QOV on the sell side.
Sure. So when you hear the term quality of earnings or QOV referred to pretty frequently, what does that mean? Well, that generally refers to, it can refer to all of financial due diligence, or you could view it as a particular component of financial due diligence, more focused on earnings, right? Quality of earnings. And so to think about it from a different perspective, what is financial due diligence, right? It's not an audit, right? Sometimes you hear the phrase kicking the tires from a financial perspective, which is, that's probably fair. But there's with the quality of earnings analysis, there's as opposed to strictly considering GAAP for a specific fiscal year or as of a specific balance sheet date, we're looking at some defined historical time period. Like I said before, it might be trailing 12 months, might be a couple years in the rear view as well. And we're not just looking at fiscal years, we're looking on a monthly basis, on a quarterly basis, trying to understand, the sustainability of the revenue streams, consistency or not of gross margins, EBITDA margins, expansion of EBITDA margins, things of that nature. So in terms of a sell-side quality of earnings analysis, and I think maybe the question was when does that make sense, or whether to do it or whether not to do it. I think we as CPAs would view it as a best practice. It's certainly not a requirement, but I think, from the seller's perspective, it can open your eyes to some things you might not have been aware of before. And, the analysis itself is, it's anticipatory in nature, right? So you'll gain an understanding in all likelihood of what to expect when it comes time for buy-side due diligence. So it should allow you to, make some decisions in advance and be more prepared and ready for a process when it's time.
Thank you for that. Bill, just being cognizant of our time, I want to shift our focus of the conversation to the buy side and staying on the accounting focus. Bill, if you could just walk us through, should acquirees look at only at target companies with audited or reviewed financial statements? Is this something that they should be heavily considering when they're on the buy side?
No, I don't think you should. I think from a practical standpoint, you don't want to rule out particular targets just because they, either do or don't have audited financials or reviewed financials. It can be a good thing, and it certainly can be helpful if those do exist. But I'd say it's probably equally important to drill down a level, right, and think not just about the audited financials, but the accounting system itself and the quality of the accounting system. Is it a accounting system that's well suited for government contracting? Is it a Uninet or Cost Point or JMIS, right? As opposed to maybe something that's not like a QuickBooks that's not ideal for project-based accounting and indirect cost pools and things like that.
Yeah, Pat, just to add to that, on the banking side, we realize it's unrealistic based on, or depending on the size of the company potentially being acquired. They may not have to do the reviewed financials or the audited financials yet. So we fully understand that the tax returns may be the level of financial documentation that we receive. We're okay with that. We will dig in a little bit and understand, to Bill's point, who are the partners? What's the CPA firm that they're working with that's preparing these financials, these tax returns? But then again, on the accounting side, do they have the accounting best practices in place? Can we trust the financials that are being presented? That's the biggest piece for us.
Yeah, no, absolutely. And along with that, you want to look at, when you're looking at those financial statements, and then you dig down to the next level down, looking at your the contract costs, contract billings, and things of that nature. When you really zero down into their business base, you want to make sure that that company, the target company, at least is tracking cost at that lower level. So when it comes time to close out and to complete the task orders or the contracts, you've got a good trail of costs that you can present to close it out, and then not have something that's just in a black hole, and have to rely on the government systems.
Thank you, Bill and John and Clint. And we've talked a lot about preparing for potential acquisitions, and I'll open us up to the floor and tapping your past experience. But what are some examples you've seen of deal killers in the past, and things to try to avoid?
I'll just briefly, I'm sorry, go ahead, Kathryn.
No, Bill, you go ahead and I'll pick up after you.
And I was just going to say, I think I saw a question come in from one of the viewers about management team and how long management team stays on post closing, et cetera. And I think that's a pretty common example of a if not a deal killer, then a deal complicator. Sometimes if the two sides can't come to terms in terms of the roles of the target company's management team post closing, where they fit in, and for how long, and on what terms. Sometimes just cannot get to a meeting of the minds there, and it either pauses or kills the process.
Yeah, Bill, and one other thing, with that combination of the management teams, we also have to look at the business systems that are being combined as well.
Yeah.
The target might have a great accounting system, but the acquirer might have a great contracts management system. So it's kind of what you want to pick and choose and take the best athlete approach.
I mean, I completely agree, and it's interesting on both of those points, although probably more on the management team integration point that Bill raised. Sometimes that might not be a deal killer up front, but it could be the reason that a transaction is not successful on a post-closing basis. Apologies, that's my dog. But it's something to focus on both the buyer and the seller side in advance of a transaction, is making sure that there's a good cultural fit and that the management teams are going to be able to integrate. And because the post-closing success is going to be critical for the buyer, obviously, to realize the value that they've put into the investment, but also to the seller, to the extent the seller's sticking around as a continuing employee, might get some rollover equity, so has a stake in that future value of the company, and might have an earnout, at stake. And at the very least, usually the sellers that we deal with have grown their company, care deeply about their people, and want their employees to be able to continue with a successful company post-closing. So that's really critical, and something that I think maybe a lot of parties going in, especially on the sell side, if it's your first rodeo, don't fully appreciate how important that component can be. On the front end, the deal killers, it usually all comes down to the economics. Quality of earnings report comes back and there's a real issue with, some of these receivables. I mean, those are the very predictable sources of conflict. So I'm going to go on mute now, so you just don't have to listen to my dogs, and then anyone else can weigh in.
I had a couple this year too that it was interesting because the economics was sort of hashed out, that was done, but there were other issues where the sellers wanted certain things from the buyer, like a board seat or a role in some diversity committee or something like that. And it wasn't in the LOI. And it was sort of side talks that happened between the owner and some of the representatives of a larger business. And in those scenarios, they're like, what do you mean? And they thought there were sort of promises, but it wasn't in the LOI. So, if it's not in the LOI, it's not really real, right? I don't think people are really on the same page. So just understand that. Same thing with the employees, like Kathryn was mentioning, if the employees are going to stay or not. If that's something really important to you, that needs to be in there. It needs to be something that's upfront and you guys are talking about. And also another thing we've seen sort of later in the process, and this goes back maybe to the very beginning, we were talking about advisors, is there were individuals who were doing this deal and on all sides who weren't really well versed in some of the GovCon issues. And there was an FCL, facility clearance, they were trying to buy the company. And they thought, this is great. We're going to buy this company and we'll get a facility clearance and we can go after classified work. It's going to be amazing. Not really understanding the issues that, look, people, human beings with personal clearances need to run these companies. And so they didn't want any of the old people there. And then when they found out, oh, we need them there, and the people who were selling didn't want to be there either. And you can't have a deal if you don't have people with personal security clearances at the requisite level, who can take over a company with a facility clearance. It's not going to work. And so things like that too, like understanding every single issue, including small business structuring. I've had deals before where everything was worked out, everything's done, and they're down the rabbit hole, and they say, oh, you know, there's this question. Somebody Googled this issue that maybe we can't have control over the board because we're a private equity firm and we're buying a small business and we want to keep it. Well, we could have structured the deal months prior to work, or find out it's not going to work and you walk away, right? Now you're $100,000 into this thing and you're just realizing that there's these problems. So that's just a few real life examples.
I think just to maybe to transition to John and Greg, right? I guess maybe the obvious deal killer is if, you know, can't get the financing in place, if, you know, financing is dependent on EBITDA and EBITDA is not what we thought it was at the outset.
Yeah, we don't want to be that roadblock. I assure you that. But Kathryn, Cy, Clinton, and Bill, those were all. I mean, they're things that we've observed over the course of time, and I'm in agreement with exactly what you all just said.
Yep. Thank you, guys. We've talked about leading up to the acquisition, both on the sell side and the buy side, and now just, you know, some of the considerations that, you know, post closing that'd be good for either party to take into consideration. And the question I'd like to start off with is, you know, what are some of the financial statement ramifications of post acquisition integration, and how does the acquiring company account for those costs? And I'll kick that over to Clint to start with this portion.
No, sure, thank you. So with this, you know, with any kind of acquisition, you know, merger and acquisition costs are right off the bat unallowable. So from both sides' perspective, you know, up until the actual close of the sale, those costs are unallowable. And then post close of the sale, you know, some costs do flip over to be allowable. Some, not all of them. You know, if you get into like integration type costs, yeah, those can be allowable. If you get into branding issues after the fact, no, those are unallowable. So it's important, at least during the due diligence period, and my experience has been to, you know, you circulate a charging guidance to the people who are on the due diligence. These are allowable, these are unallowable type activities. And then as that team starts to grow and you get bigger and bigger and more people involved, you know, you circulate that out. And as you get closer to the close date, and then after close date, you circulate another charging guidance out that it's a little bit more expanded, but it gets into things like the branding. Branding's unallowable if you go out and start advertising here and there and you're handing out trinkets to everybody. But then there are other things that would be allowable, like your time you're going to spend on integrating accounting systems, for example, or other business systems. So, you know, from that perspective, it's pretty important to get things out there in writing to folks. You don't have, at the end of the day, the government coming back and finding all these unallowable activities that you've already claimed. And then, you know, the other question you were asking here, and you know, there are savings issues that can be pursued on down the road, and because the government's going to want to see savings, you know, especially your cost type contracting officers post acquisition, they're going to want to see cost savings because they're thinking, hey, you two are getting together, you know, you're going to do great things and you're delivering a product or service to us. Now that you're together, we want to see some savings on that. So it's important to let them know, you know, how you're progressing as far as impacts on cost type work. Over.
Thank you, Clint. Appreciate that. And, you know, this has been a great conversation. The past hour and 10 minutes has flown by. I'd like to take the last 5 minutes for each of the panelists to just leave us with some final thoughts at closing here. So I'll open it up to the floor, but wanted to make sure each panelist had a couple minutes at the end here to leave us with some final thoughts.
Yeah, thanks so much. I think I'll jump in and say, I'll reiterate at the end what we started with, which is it's important that you put together a strong team of advisors from all different angles if you're thinking about approaching a transaction, either on the buy side or the sell side. In an ideal world, all of your teams, your banking team, your accounting team, your legal team, will all be talking to each other and collaborating to make sure that we work to really comprehensively structure and understand a deal for you. So leverage your advisors. That's what we're there for. Ask questions, plan in advance. Those are my pieces of advice.
I'll just piggyback on that very briefly to say, I think at least in our experience at Aronson, the more, whatever side you're on, right, the more you invest upfront in terms of planning, almost always pays off post-closing, right? Or just getting you to the finish line at all. So advanced planning, advanced planning, advanced planning.
Yeah, and I'll wrap it up from the bank side. Agree with everything that's been said already, and then, just emphasizing the relationship. Again, making sure that you're aligning yourself just like you would in your business. Align yourself with the best of the best, and those that are very familiar with government contracting. There's a lot of nuances but there's a lot of expertise out there as well. And a lot of people that are willing to help. So please feel free, if you have any specific questions, to reach out. Happy to help.
Yeah, and there's one thing I guess we didn't touch on that I meant to bring up earlier is that, and I'll get into it now, is the IP issues. So if you're a government contractor and you have certain intellectual property, or you've developed things for the federal government, or maybe your small business, you've done work under SBIR programs, there's all different rules that apply to that, and what you either had to do in the past or what you had to do before you bid on work to claim certain rights and maintain certain rights, as opposed to giving away to the government. And that's another thing we've seen come up. And again, it goes back to what everyone's talking about, is getting in early to understand, if you're a seller, knowing if you have these issues, right? You might realize it and transactions might not be worth it. And if you're a buyer, not getting so far down the road with something, and really understanding if the value is in a particular item like IP or like the future contracts, and it's all small business work. Really understanding what the implications are at the outset before you really dive into things, I think is critical. Like Bill said, it's either going to help us structure things to get around issues, or with earnout, other things like that, to close a deal, or in certain cases a deal's not going to work out, and you don't want to learn that at the end of the process. You want to learn at the very beginning. So I think that's critical.
Okay. And then from my perspective, I think a good wrap up would be, after or during the course, primarily during the course of the whole transaction, you want to stay on top of any contract cost or contract accounting practice changes that might happen on your contract base. So that's important to keep an eye on. And then secondly, after the deal closes, the contracting officers and the buying commands, they're buying stuff from you, they're spending the money. So it's always good to kind of keep them part of the, I don't want to say part of the team, but at least part of the loop, kind of handhold them a little bit, give them progress updates. This is what we're doing. This is, kind of let them feel like part of the change that's happening. They are spending money. They're spending a lot of money. You don't tell them everything under the sun, but you tell them enough that's public, and at least it kind of gives them a feel like they're part of the, they're one of the basis of the decisions that are being made. I think is a good way to put it.
Great point.
With that, I'd like to thank our group of panelists for offering their perspective and expertise in their respective fields. And I'd also like to thank our partners at Piliero and Aronson for their collaboration in making today's event possible. A follow-up email will be sent following the presentation, which will include additional materials for each of you and each of the panelists' contact information. Thank you for attending today's session. I hope you have a great rest of the day. Stay safe.
Excellent. Thank you. Bye-bye.
Thank you.
Yeah.
Thank you, everybody.